before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
Hello,
Mr.
hello,
Gray, as
people.
you get situated, there's a bottle of water to your left. And after you're seated, if you wouldn't mind pulling the microphone to you so the record picks up your testimony. Mr. Novak, your witness.
Thank you, Your Honor.
We got the
Mr.
Tyler
Gray, you're the
Robinson
elected
hearing, guys.
county attorney for Utah County, correct, sir?
Yes, I am.
All right. And so you are responsible for essentially everything that happens in and through your office, correct?
Yeah.
All right. And is Mr. Ballard still your chief of staff?
Yes.
Does that mean he reports to you in the sense of an organizational structure?
Yeah.
All right. And he's also the public affairs officer for your office?
Yeah.
And he's also, all right. And is Mr. Ballard still your chief of staff?
Yes.
Does that mean he reports to you in the sense of an organizational structure?
Yeah.
All right. And he's also the public affairs officer for your office?
Yeah.
And he's also an attorney?
Public information officer.
I'm sorry, public information officer.
Yes.
And he's also a prosecutor.
He's general counsel. He helps with motions.
And he's one of the prosecutors in this case.
Yes.
All right. Mr. Ballard testified that you and he had some general conversations about media inquiries concerning the contents of Mr. Robinson's motion to continue the preliminary hearing. Is that correct, that you had some general conversations?
Yes.
Did you ever suggest to Mr. Ballard that one approach to these inquiries would be to confer with Mr. Robinson's defense counsel concerning the media's misinterpretation of what we had filed?
No, because the rules don't require it.
Okay. Did you discuss with Mr. Ballard whether the state should approach the court concerning what, if anything, the court would permit the state to do in light of your concerns?
Again, no, because the rules don't require it.
Do the rules prohibit it?
They do not prohibit it, but neither did his order require it, the judge's order in this case.
Nor did the rules prohibit you
No.
from, I'm
No.
sorry. Nor did the rules prohibit you from reaching out to defense counsel and say, hey, you know, the media is spinning this in a certain way. We need to discuss correcting the record
No.
or clarifying media misinterpretations.
No.
All right. What about having a conversation with Mr. Ballard that went like this? Why don't we draft a statement, a single statement that we can send out to media entities and just be done with it?
I don't know that we had that conversation. I might have thought about that, but then you're getting even wider dissemination. I was unaware of how many inquiries there were that actually might have the effect of going beyond who was inquiring.
But would you agree with me that one approach could have been to issue a statement which says the state stands by the allegations in the information and the significance of any evidence will be established in court proceedings?
I don't think that that would be sufficient.
It wouldn't have been sufficient to change the media spins. Is that what you mean?
Yes, I mean, what we're concerned about is prejudice to a prospective jury. And so that could be very damaging to our ability to do that. And so we wanted to ameliorate that prejudice.
And so is it the number of media stories and the content of the media stories?
So for everybody just joining us real quick, This is the Tyler Robinson evidentiary hearing on the motion for contempt, where the defense is trying to hold the prosecutors in contempt for going on the media circuit, making statements of guilt towards, what do they call them? I forget. But basically, saying he, presume that he was guilty, saying things that would presume the public to believe he's guilty, tainting the jury in the media circuit. So they went all over the media doing that. And the defense is trying to hold them accountable and get them sanctioned for that. So that's what this is here. And I think this is the prosecutor on the stand here, if I'm not mistaken. Robert Novak, I think his name is, or I forget whatever the hell his name is.
Which led you to conclude that the state was being prejudiced?
That there was a potential to prejudice a fair trial. Yes.
Based on
misinformation.
in the media.
Yes.
But if it were accurate information, that would be okay with you?
I would not be correcting anything if it was accurate information.
Did you consult the, so we have the binding rule of professional responsibility here in Utah. Did you consult the ABA rules on this same issue?
No.
Are you familiar with them?
Yes.
Are you familiar with the ABA rule that basically says extrajudicial statements by one party are only permissible where there have been extrajudicial statements by another party?
Objection, Your Honor. Relevance. What we're dealing with here is whether or not Mr. Gray, Mr. Ballard violated the court's order. It does not refer to the ABA rule.
I think it just goes to the state of mind of both of the individuals against whom the court has already returned to the order to show cause.
Well, help me understand the relevance as it relates.
Well,
to
we have an
ABA.
ABA rule.
Jeff Gray is his
Which we
name.
cited in
The
our
guy on
reply
the
brief.
stand is Jeff Gray, by the way.
Called Fair Trial in Public Discourse, cited at pages 4 and 5 of 6 pages in our reply brief at footnote 1, which points out that the ABA guidelines limit extrajudicial statements to those circumstances where an opposing party has already made extrajudicial statements. Whereas here, what the state is saying is that it can basically correct the record or make any public statements it wants as long as there's something in the public record, regardless of where it came from.
Why my concern as it relates to relevancy is whether that's binding and whether that's even applicable. I mean, there may be like a best practices, and I'm not saying it is or it is not, but as it relates to the issue before me, I don't see how that's relevant to help me with my finding in regards to the ABA.
Okay, so I think that so far Mr. Gray has said he's aware of it, and I think that's fine.
All right, thank you. So I'll sustain the objection. We'll move on.
Is that correct, Mr. Gray? You're aware of that standard?
I am aware of the ABA standard.
I'm just going to ask you the same question I asked Mr. Ballard toward the end. Would you agree with me that in the first few weeks, especially, and continuing throughout this case, there has been substantial media coverage commenting upon Mr. Robinson's guilt?
Both guilt and innocence, yes.
Including, okay. And would you agree with me that he is entitled constitutionally to a presumption of innocence?
Absolutely.
Until the matter is submitted to the jury for deliberation?
Absolutely.
Okay. And so, do you agree with Mr. Ballard that in light of all of what Mr. Robinson's defense counsel view as prejudicial media coverage, prejudicing his right to a fair trial, that I can make public statements as to my opinion about his innocence without violating this court's order?
No, you cannot make an opinion about innocence or guilt, but I don't think that's what happened here.
Exactly.
Would you agree that the point of Mr. Ballard being interviewed over the telephone and sending emails and then appearing visually on Fox and Friends was to address media inquiries concerning specific forensic evidence in this case?
It was to ameliorate the prejudice resulting from misinformation from the media.
About a specific piece of evidence in this case?
Yes.
And you think that by crafting that Mr. Ballard's efforts to control the conversation with the media by, as he testifies, just talking about forensic testing generally avoids the prohibitions in the rule?
Whether I believe that avoids the general prohibitions, I
Yeah.
think that's one way to do it.
I know that you did not seek any guidance from the court on this issue. Did you consider filing some sort of a motion or a request asking for clarification on how the court's pretrial publicity order governs this situation?
No, I thought the court's order was quite clear.
Because there was another point in time where the state did seek clarification of the court's order, right?
Yes,
And the court clarified it.
yes.
Thank you, Your Honor. I have no further questions.
Thank you. Mr. McBride.
Mr. Gray, do you believe that the presumption of innocence means that an attorney can never respond to prejudicial media?
No,
Did you intend to violate the court's order in this case?
no,
Do you believe you violated the court's order in this case?
no,
Did you take actions to avoid violating the court's order in this case,
yes.
such as you are familiar with the court's order?
I'm familiar with it, yes,
You are familiar with Rule 3.6, correct?
yes,
And you expected Mr. Ballard to limit the statements to the media to those necessary to address the issues prejudicing your client.
yes,
This guy's so full of crap.
Now, you've been present for the testimony about the, what I'll call kind of a media frenzy about this claim that the bullet didn't match the gun,
yes.
right? As that media came out, did you meet with Mr. Ballard and discuss what to do about it?
Yes, my recollection is a little bit different from Mr. Ballard's recollection of it. What I recall is he came to me, told me that he was getting several media requests for that, and whether or not we should or could respond to those inquiries. So I spoke with him about it. I know I spoke with Chad. We discussed Rule 3.6, specifically subsection C, that indicates that we can, where we believe that there's a substantial likelihood of material prejudice. And so I ultimately told Mr. Ballard that yes, he could respond to inquiries regarding that, and specifically our concerns. The media had reported, based on the motion to stay the preliminary hearing, it indicated only that it didn't indicate on the bullet, the defendant's motion, and didn't say anything about the actual report that said it didn't indicate or exclude that it came from Tyler Robinson's rifle and was therefore inconclusive. So based on our reading of that, we could correct that. This wasn't a matter of, deciding whether it's exculpatory or inculpatory. This was a matter of correcting what that ATF report actually said.
And particularly to your client's right of a fair trial, right?
That's right.
Okay. You said you were.
Yeah, screw them. I will never bow to them. They will never, we are more Charlie Kirk than they will ever be. They can kiss my ass.
Aware of the rule, you're aware of the court's order. Were you aware of any cases dealing with media and attorneys correcting misrepresentations by the media?
I was.
For example, do you have
the Corey Richards case? Actually,
hey, good to see you.
Lead counsel in this case was also lead counsel in the Corey Richards case. I was aware of their interview that they conducted before trial to correct what they perceived as misinformation.
Okay, so let me get that clear. Lead counsel in this case, Kathy Nestor, is that right?
Yes.
She went to the media in the Corey Richards case, is that right?
Yes.
And with the purpose of correcting what she perceived to be misinformation in that case?
Yes, from the media.
And did she make any comment about prosecution's duty to correct misinformation in that interview?
There were the entire team there, or at least 3 members of that team in that report.
Of the defense team?
Of the defense team.
Okay.
And between her and her other co-counsel, they indicated that they had hoped, I believe Ms. Nestor actually stated that she had hoped that the prosecutor would come forward to correct that misinformation, but because they didn't, they came forward.
And were you aware of that case and that interview on March 31st of this year?
Yes, I was.
When did you become aware of that interview by Ms. Nestor?
Back in October of 2025.
Okay. Have there been other Have there been other circumstances in this case where you have declined and your office has declined to speak with the media?
Yes.
And if you declined in other circumstances, why did you not decline in this circumstance?
Because it was media reports where they were saying that they were misrepresenting the actual report that's in the record. And, that it did not match. That's not what the report said. Again, I'm not getting into whether it's exculpatory or inculpatory. What the report said was that the testing did not identify or exclude the bullet fragment as coming from the rifle, and therefore was inconclusive. And so we got those reports. And in those other circumstances, we had persons concerned about what they perceived as misinformation. And my conclusion was, we're not going to go out there and talk about those things because, quite frankly, I didn't know whether or not how the defense would use that information. And so I decided, no, we're not going to comment.
Wait a minute. He said that they got persons that were concerned about misinformation. I want to know who those persons are. What persons is he referring to? Is he referring to the FBI? Is he referring to Erica Kirk? Who are these persons he's referring to that directed him to go out there and talk to the media?
Comment on that kind of stuff.
Okay, so there have been other circumstances where you said, no, we're not going to talk to the media about X, Y, and Z.
That's right.
But in this case, you made an analysis and said, yes, we're going to talk to the media in this case because of how important the issue is.
Yes.
Nothing else.
All right. Mr. Novak.
Mr. Gray, I don't know anything about the Corey Richards case, so let me just ask you a couple questions.
Sure.
You had watched some sort of a media interview that you say that Ms. Richards' counsel conducted before trial.
Yes.
And did you think that was appropriate under the rules?
I think they went beyond what they could do, but I think it is appropriate under Rule 3.6 under the right circumstances like this case.
So it really depends what it is you say that puts you close to the line or over the line set by Rule 3.6 in the court.
Sure, I mean, you have to be careful in what you say. I mean,
Okay.
we do our very best to be careful.
And was your office prosecuting that case?
No.
Okay. Did the county attorney file anything with the court concerning those public statements, to your knowledge?
I'm not aware of that. I talked with her. She was the one that advised me of that, and that's why I became aware of it. But I don't know whether or not they decided to or not. There are many reasons why you may or may not file something. I know that she wasn't happy with it.
When you say she, you're referring to the county attorney?
Margaret Olson from Summit County.
I see. And you don't know if Summit County sought any judicial review of those extrajudicial
Yeah,
statements?
I do not know.
Understood. Yeah, thank you, Your Honor. I don't have any further questions.
Thank you. Anything further for this witness?
No.
Mr. Gray, thank you. All right. Mr. Novak.
No further witnesses. Thank you.
All right. To the state.
No witnesses, Your Honor.
All right. We can proceed to, I'll defer to the parties. Mr. Novak, you have about 8 minutes for argument. The state has a little bit more than that. So as the parties wish to proceed.
I'm prepared to do it now if the court wants to continue.
Yes, my intent is we'll do that. Then that will conclude this particular as it relates to the OSC, and then we'll turn to the motion in limine as it relates to hearsay, giving the parties time to argue that as the court has reviewed in detail the motions, which were detailed, and the court appreciates that. So we'll have a brief oral argument on that, and then we'll go to the last issue that Mr. Novak brought up and address that as well. All right, turning to Mr. Novak.
Thank you, Your Honor. And I want to be careful to be clear, at least from our perspective, that there are two issues here. One is whether the evidence supports a finding of violation of the court order by Mr. Ballard and or Mr. Gray. And then the question, if the court does make that finding, is what are the consequences? So I'm going to really deal with the first part first and the second part second, unless the court wants to bifurcate it and issue its findings on whether or not there's been a violation, in which case, if the court finds that there has been a violation of the court order, then we can address the remedies.
We can address that today. Thank you. In regards to your argument and what you are advocating for.
All right, so the court would like to hear all of it at once. That's what I'm hearing. Okay. So first of all, the court's order concluding that there was a preliminary finding that we had made a preliminary showing identifies 3 elements to the contempt. And Mr. Ballard essentially admitted to the first 2 elements. He was aware of the orders, and there was no reason why he was unable to comply with them. So the third element is whether the order was violated. Now, I acknowledge that the court's order uses the word intentional, but I would ask the court to look again at our pleadings concerning whether intentionality is an element of the offense. And the reason why that's important is because many courts, as I cited in the brief, so I'm not going to cite all those cases again, say that where the order is in the nature of an injunction, the court doesn't need to make a finding of intent. Every order is different. This is an order enjoining conduct. And so if somebody violates, knows of, and has the ability to comply with an order enjoining conduct, and the order is violated, there is no need to show intent. However, what I will argue to the court is whether or not the court is going to add that element of intentionality. I think the evidence is clear that the violation was intentional, or it was so reckless, and I will use the legal phrase extreme recklessness, that there's a very fair inference of intentionality. And I don't say this lightly, and this is one of those situations where lawyers and judicial officers sometimes cringe, but sometimes the cover-up is worse than the original conduct. I know we've all heard that before, and we all know what that means. But I find no credibility in Mr. Ballard's sworn testimony that he only intended to communicate with the media generally about bullet fragment analysis. He used phrases like "this bullet." He's responding to misconceptions in the media about what the defense said in its filing. He's talking about the bullet fragment analysis in this case. And I have trouble accepting Mr. Ballard's explanation that he really never said anything about the bullet fragment analysis in this case. Especially, I mean, the most clear example, frankly, is his statement in Exhibit 7, which is his statement on Fox and Friends. Because he talks about this bullet, the bullet, the bullet. He's not talking in general terms. He's not talking in generic terms. He's not a ballistics expert, although in some of these exhibits you see that the journalists interviewed ballistics experts. Mr. Ballard is trying to influence public perception about examinations in this case. And I think to say, oh, I'm not talking about this case, I'm only talking about ballistics generally, is belied by the context in which the statements were made, the motive that Mr. Ballard and Mr. Gray admit they had in engaging in extrajudicial statements, and the content of those statements. Mr. Ballard also acknowledges that he made statements about future examinations and his expectations about what future FBI and ATF reports would say in this case. So even if Mr. Ballard has this, what he thinks is a safe harbor, oh, I was just talking about bullet fragment analysis generally, he is then saying, oh, and we'll have some more reports in this case soon that will clarify this. So he's actually talking about what he believes forensic experts will do and say in the future, which I think not only violates the rule in and of itself, but shows the overall problem with his excuse.
Exactly.
The reason why we asked Mr. Ballard and Mr. Gray if you can turn this around and say, since there's been all of this negative media coverage, can I go on a public relations tour and state, in my opinion, Mr. Robinson is innocent extrajudicially, beyond the fact that he has a constitutional right to the presumption of innocence, which the prosecution has an obligation to embrace and uphold, is because if I can do that in response to media coverage, then this court's order and the rule are completely swallowed up. In other words, in a case where there is media coverage, which is not the result of interviews by the defense, I can go do those things, then this court's order has very, very little meaning. And Rule 3.6 has very little meaning. And that just can't be the way it works. So at a minimum, their conduct was extremely reckless. And that in the law is the same as intent. But again, I don't believe that that's what this court has to make a finding in order to confirm the court's initial preliminary finding of a violation of this court's rules. It's interesting, Your Honor, that the state's attorneys have already decided that the recent media coverage about the bullet fragment analysis has prejudiced their case, because they've been saying in this courtroom and in pleadings that we can't prove that any of the media coverage in this case has prejudiced Mr. Robinson. They've been saying, pick a better jury, have a better questionnaire. Maybe there's a venue issue, more peremptory challenges, individualized voir dire. And this court has said the same thing. But when it suits them, they say they've already determined that their case is prejudiced. And so they need to correct the perception in the jury pool so that they can have a right to a fair trial. And it's offensive to me, but it's deeply ironic that when it suits the state, we can't prove prejudice. And when it suits the state, they've already concluded that there's prejudice, without even taking a moment to say to this court, we're very concerned about this. We weren't concerned before about all of the negative media coverage about Mr. Robinson and his life, but now we're concerned about the media coverage concerning this piece. And so, Judge, what are we going to do about this? I am confident that if the court received an inquiry from counsel that said, there's an urgent matter here, we'd really like to have a conversation with the court about what is acceptable under this court's order, this court would have convened a hearing. This court convened, as I recall, a conference call on like 6 hours notice back in September when the court wanted to manage this case quickly because things were happening. And the court's staff got everybody on the phone, and the court made some decisions, and then those decisions were docketed. There is nothing that stopped the state from asking this court to either clarify its order or approve some press release, even if it was over the defense's objection, that would be consistent with Rule 0.6 and the court's orders and Rule 3.8. So now in my remaining time, I'm going to go to the remedies. I think that the number one remedy in this case, Your Honor, is for this court to preclude the state from seeking the death penalty against Mr. Robinson. The court said at an earlier time that if the court found there were violations of its orders, that it could order somebody to do continuing education, it could impose fines, it could do all kinds of things under the civil remedies. That is true. But what we are talking about is the
That's
state,
interesting.
without any guidance from this court, going out and trying to influence the public perception of this case, so that when people come into this courtroom, and they may be jurors in this case, they have been exposed to the state's extrajudicial statements about what the evidence will or will not show before the first witness is ever sworn to testify in the trial, before any exhibits are ever received into evidence. And as Mr. Ballard said, the media spin will never change. The media will do whatever the media wants to do. I'm going to return to that as well. What was going on here was an attempt to influence the jury pool, because that's the only thing that cures the prejudice, is correcting what the state is concerned are the perceptions of potential jurors. And so that is the remedy that is commensurate with the extreme recklessness and the motives of the state. We asked this court to compel some discovery, but Mr. Ballard was quite frank. We need to change public perception of what the evidence is or might be before we ever pick a jury.
They did admit to that.
There are other
Absolutely.
lesser remedies, but we've already been through proceedings concerning how to remedy the pretrial publicity, the electronic publication of these proceedings. And the court has already said in other contexts, we're gonna have a more thorough jury questionnaire. We're gonna have more voir dire. We're gonna have individualized voir dire. We're gonna have venue issues. I'm not saying that the court has promised to change a venue. That's not what I'm saying. But the court this morning said there may be an appropriate venue issue here. So there's no additional consequence for the state's misconduct here. We're already at the point where we've got to pick we have to much more carefully pick a jury because of what has happened in this case over the last 9 months. And now the state has compounded it horribly. We can't wait until we start picking the jury to find out what harm has been caused. So we think that's the first remedy. The others are the remedies that the court has already said are probably necessary in this case. I don't want to be flippant, but I don't really care whether Mr. Ballard attends a continuing education program or not. All I care about is my client's constitutional rights. And referring Mr. Ballard or Mr. Gray to the state bar, as Mr. McBride referenced, I'm not saying he suggested that, at the argument on the motion, doesn't protect Mr. Robinson's constitutional rights. Mr. Levitt's sanctions weren't affirmed by the Supreme Court until years after that case ended. That doesn't protect Mr. Robinson's rights in this case. I just want to say one other thing, Your Honor. One of the reasons why extrajudicial statements are strictly controlled is because lawyers can't control the media. We can send them an email, we can make statements on the phone, we can sit for a 15-minute interview. Journalists will cut and paste and shape articles to fit their purposes. And that's why it's extremely reckless to do what Mr. Ballard and Mr. Gray did. If they had put out a press release, especially one approved by this court, that said the state stands by the allegations and the information, evidence will be presented at trial, Mr. Robinson has the right to the presumption of innocence until the trial has concluded, we wouldn't have this problem at all. Because the media, all they could do is cut and paste pieces of a press release that would be totally in conformity with this court's order and rules 3.6 and 3.8. And so they let Fox and TMZ and other media entities cut and paste whatever was important to them. But that doesn't relieve them of the responsibility, and it also does not undermine what I think this court unfortunately needs to find to be true, which is that Mr. Ballard's attempt to say he wasn't talking about the ballistic testing in this case is simply lacking in credibility. Thank you, Your Honor.
And counsel, I do have a question for you. So hypothetically, if the court finds a violation, do the interests of justice require proportionate sanction?
Yes. And I think in light of the remedies that this court has already said are going to be necessary in this case, the sanction that I've suggested is proportionate, and it's in the interest of justice.
Thank you, Mr. Novak.
Thank you.
Turning to the state.
Your Honor, I'll start with defense counsel's assertion about credibility of Mr. Ballard. I view the evidence completely different. It seems to me that Mr. Ballard is extremely credible. His statements that were reported through several media entities all said the same thing, which were
Not a
I'm not going
chance
to
he
talk about
shows up
specifics of
in
this
court.
case, but in general, when you have an inconclusive report, it means this. Did he say the bullet? Yeah, because he was referring to the bullet referenced in the previous sentence. And that was consistent throughout all of the media that we looked at. And the Fox News story, when you see that, you can tell it cut off the last word when it begins his next sentence. That's how quickly it starts. And so that's consistent. His testimony that he was referring to a general inconclusive result is consistent throughout all media entities here. But the reality is it doesn't matter anyway, because Rule 3.6b says attorneys can reference matters in the public record. And this report was in fact in the public record by this time, because defense counsel attached it to one of their pleadings. The court ordered that it would be public, and it was public. What Mr. Ballard's efforts at being general rather than specific show is a measured and thoughtful effort to correct the unfair prejudice that faced his client, not an effort to prejudice defense or the defendant. That shows a measured and thoughtful, deliberate approach, not an intent to violate the court's order. The statement about what future FBI reports would say, that's misleading. That is not what the testimony was. Mr. Ballard testified, I talked about what the future FBI and ATF reports may say, and that was in reference to the motion to continue the preliminary hearing that talked about the lack of discovery of underlying data supporting the scientific reports. That's what the testimony was. Despite what Mr. Novak may want to say here, we're limited to what the testimony is here, and that's what the testimony was. The hypothetical, where defense says, well, taking the state's position at face value, then defense counsel could get up and say, I believe my client's innocent. That's comparing two completely different things. Rule 3.6, the comment to Rule 3.6 says, attorneys should not be saying they believe someone is guilty or innocent, right? That's not what Mr. Ballard said. He didn't come up and say, I believe defendant is guilty. That's not what he said. And with regard to the prejudice to the case, right? Mr. Novak talked about, well, it's not consistent.
Hey, Daisy, good to see you.
The defendant being prejudiced, then we can handle all this through voir dire and expanded veneer and all those things. But when it's the state being prejudiced, you can't. You have to actually correct the record. Well, there's a difference here. Well, the first question is, are they being prejudiced unduly?
Yes,
Under
they did.
3.6, that's the language. Undue prejudice. Well, is it undue prejudice? When the evidence, and we all know this, everyone in this courtroom knows that media was misrepresenting the evidence here. That's what makes the prejudice undue, right? If there's a false narrative that's being pushed, that's undue prejudice. Under 3.6, that's when you step in and correct it. Now, that's why the comment to 3.5 or 3.6, comment 5 to rule 3.6 is helpful, is because there are certain things that can create undue prejudice, such as an attorney's opinion on guilt. So if Mr. Gray had stood up at the initial press conference in this case and said, "Trust me, I am your elected county attorney. I believe the defendant is guilty." To correct that undue prejudice, yes, defense counsel could have got up and said, "Members of the public, it doesn't matter what the county attorney said, what the county attorney believes. What matters is the presumption of innocence, and we've got to wait for a jury," and all of those things, right? But that would be undue prejudice, right? Not the fact that he's been charged with a crime, not that there's an affidavit of probable cause and the contents of that, not that there's pleadings in the case and the contents of those pleadings. And that brings me to the point of, this is why it's so important that attorneys satisfy the duty of candor to the court, is because when an attorney files something with the court, we all know an attorney has a duty to this court to have candor and to be honest in what they represent. Why? Because then when the media reports on it, there's some assurance that there's some validity to those statements. That's why some of this, what we're dealing with, is so upsetting, is because it generates from a pleading that claims that frankly was misleading, I think. And obviously the media all thought it meant what they said it meant. All right, with that, let me turn to, I think, what really is the crux of the issue here. You got to start with the standard. The standard of proof is clear and convincing evidence. In order to find Mr. Ballard or Mr. Gray in contempt, the court has to find by clear and convincing evidence that Jeff Gray and or Chris Ballard intentionally violated the court order. Now, defense counsel has taken issue with that intentionally language, but the issue they take generally comes from a case and a line of cases that predates the Von Hackey v. Thomas case, which is a Utah Supreme Court 1988 case.
Later,
which,
Deb. Thanks for stopping in.
Promulgates the intentional standard. That same standard was reiterated in Sumner v. Sumner, a 2012 Utah appellate court case. These are cited in the state's brief, I should mention.
It's exactly what they were doing.
The Kohler v. Allen 2020 Utah appellate court case. That's the standard. Proof by clear and convincing evidence that these attorneys intentionally violated your order. In this circumstance, the defense can't prove, and I don't think the court can find, the actus reus, much less the mens rea, which is much more difficult to prove. When you look at the actus reus, these statements did not violate the order, which explicitly refers to Rule 3.6. That last line of the order says, right, this order does not preclude the attorneys from speaking to the media. See Rule 3.6b, right? 3.6b allows attorneys to talk about material in the public record. And 3.6c, which allows attorney to correct extrajudicial statements that prejudice their client's rights. It did not violate the rule because the reference to the test, the report from the ATF, was a matter of public record, docket 284, which is specifically allowed by the rule. But Mr. Ballard, in demonstrating his measured response, took an additional step to avoid potentially prejudicing the defendant's rights. Rather than saying, I'm going to read to you the report, media, that talks about this case, the bullet in this case, and the results. I'm going to read to you the report that says not only the part that the defense included in their pleading, that they could not tie the bullet, that they could not identify that bullet as having been fired from that gun, but they could not exclude it. And not only that, but they could tell this is a 30 caliber class round. Mr. Ballard did not do that. He could have under 3.6b, but he didn't. Why didn't he? Because he was taking a measured and deliberate approach to avoid violating this court's order, to avoid violating his ethical duties. Under 3.6c, he was correcting an unduly prejudicial media to protect his client's right. Why is it unduly prejudicial? Because it was false, right? This narrative that the bullet didn't match was false. Everybody in this courtroom knows that that narrative was false, and he was correcting that narrative. It's hard for me to think of a circumstance where 3.6c would be more directly at issue. We have here perhaps the most high-profile murder case in the world. Certainly one of the most high-profile murder cases in Utah's history that has generated extraordinary attention from the media and from the public. We have here, not only that, we have here reports that are that are misrepresenting the evidence and claiming that it completely exonerates the defendant. And those reports are false, right? Hard to see a circumstance where 3.6c would not be more at issue. So, Your Honor, I don't think the court can even find the actus reus here. I don't think the court can find that the statements that were made by Mr. Ballard violated 3.6b or 3.6c and therefore violated the court's order, much less that Mr. Ballard and Mr. Gray intended to violate the court's order. When it comes to the mens rea, the intent, you can see by the statements, by the testimony, that both Mr. Ballard and Mr. Gray were deliberate. They talked about Rule 3.6. They were aware of 3.6, 3.6c.
Oh, exactly.
They're aware of other cases where corrections of the record had been brought up, including by lead defense counsel here, where she.
And on top of that, he's using this court hearing to continue to contaminate the jury pool.
Corrected the public statements and said the prosecutor should too, and they made measured statements Mr. Ballard made measured statements to the media that were deliberate and did not go beyond what the rule allowed. He did not say, "I believe he's guilty." He did not say, like Mr. Levitt did, "I believe my witness." We believe the witness. He did not refer to evidence that would not be admissible. He referred to evidence that was in the public record. Finally, Your Honor, I think in conclusion, the defense has not shown and the court cannot find proof by clear and convincing evidence that Jeff Gray or Chris Ballard intentionally violated the court order or violated the court order at all. As I mentioned before, we've taken this matter seriously. At the very outset, you can see that the state, the day the defendant was arrested, was sending out letters to the media, to police chiefs and the law enforcement agencies saying, be aware of these rules. If you talk to the media, you have to abide by these rules. We suggest you don't talk to the media. If you have questions, talk to us. You can see that we've taken this very seriously from the outset. We've taken it very seriously up until this date. We have a duty to justice and to our client to make sure that our client gets a fair trial and that the truth is out there. And this, of course, this issue has brought the issue front and center to us, and we've discussed it, and we've discussed how we can be absolutely certain that we do not cross the line. We don't want to cross the line. We want to stay as far away from that as possible. We believe we want the state, we want Mr. Kirk, we want his family, we want everyone, including the defendant, to receive a fair trial. We don't want to do this again. We want to do this right the first time. We believe we've done right this far, and we will exercise extreme care to continue to do right here, even if that means revising some of our protocols in interacting with the media.
Big time.
Thank you, Mr. McBride. I do have one question for you. With reference to the final page of Exhibit 3 and in the context of correcting the record, And evaluating undue prejudice, how does the state contend that Mr. Ballard's statement, and I'm quoting, "He is presumed innocent. The ultimate decision will be up to the jury. We believe we will be able to overcome his presumption of innocence."
Thank you. Yes, first off, we don't know the exact order in which the statement was received. But I think there's two things that are important here. One is the reference to "he is presumed innocence," right? That shows that Mr. Ballard was intentional about making that clear, right? The jury will find guilt. That last statement, "we believe we will be able to overcome the presumption of innocence." This is a reaffirmation of the state's certification under Rule 11 that we have the evidence to proceed with the case. In good faith, we believe we have the evidence to proceed with the case. Every attorney that files a pleading in this courtroom
I agree as well.
certifies that they believe
The
the
judge has
matters
been pretty
contained in
good
that
so
pleading
far.
are supported by evidence. And that's what this is. It's a recertification. We believe we have the evidence to prove this case. All of these media reports
Definitely.
do not undermine that good faith certification that we made when we filed the case. And I think this is where it's helpful to look at. I have this here. We cited a case, Kansas, State v. Wright, 583 Pacific 3rd, 174, where the prosecutor in that case in jury selection. So this is a much more direct, this is right to the jury pool who's going to try the case, right? In that case, the prosecutor says to them, see if I can find this quote. Oh, I've got the wrong pleading up. Okay, I had it on the page.
It's all
Thank you for asking
emotional
that question.
manipulation. Absolutely.
I meant to cover this. In State v. Wright, 583 Pacific 3rd, 174 on 194, this is a Kansas Supreme Court case from 2026. The county attorney speaking to the veneer, the jury panel for jury selection, says this: "So as the county attorney, my job is to prosecute cases that are brought to my office that I feel we can prove beyond a reasonable doubt." Then he continued, "That is the burden that the state willingly accepts when it filed charges and brings cases forward." So the state understands this burden and intends to prove that through the course of evidence this week. And the Supreme Court ruled as follows: rather than an improper personal opinion on Wright's guilt, the prosecutor's comment here simply explained the prosecutor's role in the proceedings and reiterated the state's burden of proving guilt beyond a reasonable doubt. A prosecutor in a criminal case cannot ethically prosecute a charge that the prosecutor knows is unsupported by the evidence. That's what was happening here, Your Honor, is saying Mr. Ballard testified. This answer was in response to the question, do you still have a case? Right? Does your case fall apart here with the evidence? And his opinion was not, "I believe he's guilty." It was an opinion directly tied to the evidence.
That's a complete bullshit. That's not what that was not the question.
This case. And it's nothing more than a certification that all attorneys make when they make filings, and that the county attorney made when filing the information in this case. It's much less prejudicial than anything the attorney said in State v. Wright, because it's directed to the media rather than the jury veneer. And it's not prejudicial anyway. I don't think anyone would be surprised to learn that the prosecutors in this case believe they're going to be able to prove it. In fact, I think if the public thought we were prosecuting cases we did not believe we could prove, that would be frankly shocking, because it wouldn't make any sense. I think everybody knows that we believe we can prove this case, and we intend to do so through the evidence, not based on personal opinions that are endowed on us through our authority as prosecutors, which seems to be what Levitt claimed in that case.
Thank you, Mr. McBride. All right.
Can I beg the court's indulgence for 90 seconds?
I will give you 90 seconds, Mr. Novak.
Thank you, Your Honor. I think we all want the court to be clear on the law with respect to the third element and intentionality. And Mr. McBride is not correct when he says that all of the cases that we cite for the proposition that violation of an order enjoining conduct requires proof of intent predate Von Hayek. That is not true. And so what I want to just remind the court is that in 2019, the United States Supreme Court said, and this is at the bottom of page 10 of our reply, the United States Supreme Court said, quote, "We have explained before that a party's subjective belief that she was complying with an order ordinarily will not insulate her from civil contempt if that belief was objectively unreasonable." That's Taggart v. Lorenzen, a 2019 Supreme Court case. And in the same year that Von Hayek was published,
Hey,
the
Katie, good to
United
see you.
States District Court for the District of Utah said that civil contempt for violation of a court order need not be willful. And now I'm going to quote from the District of Utah opinion. "In order for a party to be cited for civil contempt, a court must find that the party violated a specific and definite court order and that the party had knowledge of the order sufficient to put him on notice of the prescribed conduct. Nevertheless, the disobedience in a civil contempt need not be willful because the purpose of civil contempt sanctions is remedial." That's In re Skinner, a 1988 published decision in Bankruptcy Reports, District of Utah.
Thank you, Mr. Novak.
And I have nothing further unless the court wanted to inquire of me concerning anything Mr. McBride said.
No, thank you.
Thank you.
All right, we're switching gears, going to the motion in limine to exclude hearsay statements as mentioned in the
He's doing a great
briefing.
job.
Again, I will note that the court has examined those briefings in detail, and so the court wishes for limited argument as the briefing provides a lot of guidance from both sides on the.
And what they're going to argue now is whether the state, because the state intends to introduce a bunch of police officers' hearsay testimony saying, "Oh yeah, I saw this, I did that," but without any evidence to back it up. And the defense doesn't have anything to be able to, and the defense doesn't have any evidence yet to be able to prove, what they're saying is true or not yet. So that's what that is about.
The parties' positions. And so if the parties would like to take up to 15 minutes to argue that, you certainly can. And then we'll go to the final issue that Mr. Novak brought up in the beginning. And as this is defense's motion, we'll turn to defense. Mr. Burt.
Morning, Your Honor.
Good morning. Well, afternoon now.
Afternoon, I guess. Judge, as the court knows, and as you've just noted, there's been extensive briefing here. I'm not going to get into all the technical arguments, and there are many here. But the briefing outlines 6 different bases for the court to find here that the use of hearsay evidence in this particular preliminary hearing in this death penalty case is unconstitutional under the federal constitution. The state constitution has separate rules, as we outline in the brief, and I know the court's familiar with those. But the constitutional issues raised under the federal constitution are unique. For the most part, they have not been addressed by any Utah court, with one exception, and that's the confrontation clause objection that is addressed in Timmerman. But as to our other arguments, procedural due process, equal protection, the Sixth Amendment right to counsel, those issues have not been addressed. And there's, of course, one issue, separation of powers, that's a state law issue. That has also not been addressed by any Utah court. But I wanted to take just a few minutes with the court, if I could, to outline why this motion is
I will
important
take your
in this
word on
particular
that. I
case.
haven't looked
I don't
into
think
it.
that's really outlined in the motion, but I think it's important for the court to consider. And I know the court has not reviewed the exhibits that have been submitted to the defense from the prosecution in terms of what they're going to present at the preliminary hearing. But I'll represent to the court that for the most part, the state, and I'm sure they'll correct me if I'm wrong on this, intends to rely almost exclusively on hearsay evidence at this preliminary hearing
Very true.
to make out the elements of the charges and allegations, and especially the death penalty eligible allegations against Mr. Robinson. And probably most problematic from our standpoint is that the central witness who's going to be presented against Mr. Robinson is a witness who the prosecution and the federal government have given promises of immunity to. And in lieu of putting that witness on the stand and subjecting him to cross-examination, they met with this witness outside the presence of the defense, asked a series of leading questions that the witness was asked to agree to, videotaped it, and the state proposes to introduce that into evidence. In addition, a prominent feature of the evidence at the prelim will be a number of forensic reports by federal and possibly some state law enforcement forensic examination examiners. And those reports, for the most part, are simply conclusory opinions about certain findings that were made. There's no indication on the face of the report as to the methodology that was used or the reliability of those methods. The reports are simply going to present the court with conclusions. And then the state is going to rely on Section 1102 of the Rules of Evidence to urge this court that those statements by law are reliable evidence. And that's the gist of the problem here, because 1102 in combination with Article 1, Section 12 essentially removes what was supposed to be this court's function at the preliminary hearing, which is to assess the reliability and the credibility of the evidence. And the intent of Article 1, Section 12, if the court goes back into the legislative history, was specifically to remove the court.
That's funny. Barron's got a daisy. I got me a daisy too.
Court's discretion to decide whether certain evidence was reliable. And that's where the separation of power issue comes into play. Now, that we say violates the federal constitution in a number of respects, and also the state separation of powers provision. But I wanted to point out to the court that the state's position on this issue is really contrary to the position they've taken on almost every other procedural issue that has been raised in this case. And the prime example is the one just presented to the court in connection with the OSC. One of the things that Mr. McBride said was, we have a duty to make sure the truth gets out there. And similarly, the defense has a duty to make sure the truth gets out there. And how they do that in this system, traditionally and historically, has been through the use of cross-examination, confronting adverse witnesses. Another example of the inconsistency that's being urged upon the court in the state's opposition to this motion. The court will recall the state's position on our motion to exclude cameras from the courtroom. And Mr. Grunander began his argument to the court with this statement: Your Honor, mischief lurks in the dark or in secret, or that's at least how many people view the workings of government, even the courts. And while this is primarily the media's fight here, we do not represent the media. We strongly support open and transparent proceedings in this case so that the public will trust the process here. There are conspiracy theories that abound. There are questions being raised, and the best antidote for falsehood is the truth, is accuracy, is the actual real proceedings. And that's at page 214 of the hearing on April 14th. And similarly here, Your Honor, the defense's right to cross-examine and confront adverse witnesses, immunized witnesses in this case. We're going to provide the bulk of the evidence against Mr. Robinson. The purpose of our doing so,
I suspect that the contempt ruling will go towards the defense. I think they will get, judge rule contempt. But I do not think he will, what do they call it? It's not sanctions, but to fix it, the fix or whatever. I don't think he's going to do I don't think he's going to go along with them removing the death penalty. That's my 2 cents.
is to get at the truth, to lead to transparency. And one of the articles that the state has cited to the court as indicative of an analysis that's relevant to this issue is an article by a former district attorney who, this is the Bowden article that the state cites. And one of the things that Mr. Bowden, former prosecutor, says in his article that the state cites is he's addressing the issue of why it's important to have adversary proceedings at pretrial proceedings such as preliminary hearings. And he says, this is at page 1148 of his article, a system without adjudication lacks transparency. The public normally has no way of learning why prosecutors make the offers they do or why certain cases reach certain outcomes. The opacity prevents the public from understanding how criminal courts function. It frustrates journalists and scholars who wish to study criminal courts, and it distorts democratic feedback as voters are left with little idea of how these institutions work. And the court, in its rulings on public access, and even this morning, you have also emphasized transparency as a goal of the criminal justice system. So this motion asks the court, how can we further transparency by relying exclusively, or almost exclusively in this case, on hearsay evidence that implicates Mr. Robinson in a death penalty case? And we say to the court that if the court looks carefully at the cases we've cited on the federal constitutionality of this practice, the court should determine that it's simply unfair to proceed on the basis of hearsay in a case where Mr. Robinson's life is at stake. The federal constitution requires that people who are facing parole revocations have the right to confront and cross-examine witnesses. The US Supreme Court has determined that people facing probation violations have a right to confront and cross-examine witnesses. The state Supreme Court has determined that people at suppression hearings have the right to confront and cross-examine witnesses. The state Supreme Court has determined that people who face sentencing have a right to confront and cross-examine witnesses. And we say that due process, equal protection, and the other provisions we cite all point in the same direction, which is that the court should not allow the use of hearsay to make the determination in this case that Mr. Robinson should or should not be bound over for trial. And I'll be glad to answer any questions the court may have. I know there are
He's making a good argument.
So if the court does have questions, I'm prepared to address them.
I do. I have one question. I'll be asking both sides this question.
Sure.
In the court previously indicated, and you noted it, that it wasn't reviewing the exhibits ahead of the preliminary hearing in order to go in with an an open mind and weigh it accordingly. Is it your request that the court review the proposed state's exhibits that relate to this motion prior to the preliminary hearing?
Your Honor, I think it would be helpful to the court to do that because I think the court would then have a better context of just how central hearsay is going to play in this case. And also, especially in regard to the crucial witness, the immunized witness, how the state structured that hearsay. And I think if the court did that, it would clearly see the importance of cross-examination and confrontation. So I would have no objection to, and I would urge the court to do that.
And do you have those exhibits, those exhibit numbers?
You hear him say the immunized witness? That's interesting. It sounds like they gave somebody immunity to say something.
And if you need time to confer with your team as I go to the other side, I don't expect you to just come off with those numbers off the top of your head.
Sure. I know the court, the state provided those to the court. I think there was some email traffic about how the court then gave them back to the clerk, but I think they're still in the clerk's possession. The state will correct me if I'm wrong on that.
Right.
But they're the state's exhibits. So
No, you're right. I know, but I'm wondering if there's specific ones that you want to identify that relate directly to your motion that you wish the court to review.
yeah, sure. And if I could have
I agree.
identify what those exhibit numbers are.
All right, so I'll turn to the state and
Great.
and again, I'm not trying to put you on the spot there. All right, Mr. Ballard.
Thank you, Your Honor. The Utah Supreme Court has already rejected the defendant's argument in State versus Timmerman. This court can't overrule the Supreme Court. And I think it's fundamental, or it's important to think about the fundamental reason why the court held in Timmerman that the Sixth Amendment right to confrontation does not apply to preliminary hearings. And it's because of the very, very low burden and low standard that the state has to meet at a preliminary hearing. All we have to show is probable cause. The magistrate at a preliminary hearing isn't making any factual findings. The issue is just whether there is a reasonable probability of that an offense was committed and that the defendant committed it. And in making that decision, as Your Honor well knows, you have to draw all of the inferences in favor of the state. You can't weigh conflicting evidence. You can make.
Yeah, and that's interesting because I think Lance Twiggs is actually the one that set him up to begin with. I think he's the one that actually authored those text messages. So the fact that they're giving him immunity is really concerning.
Make only very, very limited credibility determinations.
If it is him.
So even if the defense could impeach a witness to some degree through cross-examination, like the fact that this witness has been granted immunity, it doesn't matter at the preliminary hearing because the magistrate's duty bound to ignore those blemishes and draw all reasonable inferences in favor of the state. So even if the state's only witness to a robbery was a convicted forger who wasn't wearing his glasses when he saw the robbery and who had a grudge against the defendant, even if the defense could bring all of that out on cross-examination, it's irrelevant to the probable cause finding because it's such a low burden. That's an extreme example. I don't think the state would ever bring charges in a case like that, but we do have
he is correct on
an
that.
example
That's
that
why
is
it's such a high
similar
bar to
in
meet.
scope to that. And that's State versus Drozbecki. That I think is how you pronounce the name, Droesbeke. That's 2010 Utah App 275. In that case, you had a child victim of sexual abuse who reported the sexual abuse to law enforcement, reported it during a CJC interview, but then took the stand at the preliminary hearing and recanted those allegations. That there was still sufficient evidence under that situation to bind the defendant over, even though the witness recanted those allegations, because there was a reasonable explanation as to why the witness might have been telling the truth when she reported to the police and during the CJC interview, and why she might have recanted at the preliminary hearing. So that's the standard that the court is applying. And so defense talks about we have to have reliable evidence. And the state absolutely agrees that we have to have reliable evidence, but reliability, the degree of reliability depends upon the circumstances of the proceeding. So is hearsay sufficiently reliable for a conviction beyond a reasonable doubt at
Yeah, I
trial?
wonder if
Certainly
Twigs
not.
is only cooperating
But is
because they offered
hearsay
him immunity
reliable enough to be able
They
to
did
make
put
this
him under
low
witness
probable cause
protection
finding? Yes,
for
it
a
is.
while.
And that's why Timmerman held that the Sixth Amendment right to confrontation does not apply at preliminary hearings. And that's why nearly every other state court that has examined this issue has found that the Sixth Amendment right to confrontation does not apply. Timmerman collected those cases as of 2009. You've also got the Ninth Circuit in Peterson versus California, and we've included all of these cases in our brief. In fact, if this court granted the defendant's motion, it would be going where no other court has gone before. This court would be the first court to find that the Sixth Amendment
Sadly,
right to
that's
confrontation
true.
applies at a preliminary hearing. Because Timmerman is clear that the Sixth Amendment right to confrontation doesn't apply at a preliminary hearing, defendants trying to rely on other federal constitutional provisions. But defendants' attempt to do that violates the rules of constitutional construction, legal interpretation, because it would create contradictory constitutional provisions. What defendant is trying to say is even though the Sixth Amendment right to confrontation, which we know would provide the right to cross-examination and therefore prevent the state from relying on hearsay, even though that right doesn't apply at the preliminary hearing, there is some other constitutional right that could somehow indirectly provide that right. But then we would have two conflicting constitutional provisions. And that's not how we read the Constitution. That's not how we read statutes. We read them to be in harmony with each other, different provisions to be in harmony with each other, and to not render a different provision superfluous. If you could provide the right to confrontation through the Sixth Amendment right to counsel or 14th Amendment right to due process, then what work is the Sixth Amendment right to confrontation doing? It just doesn't make sense to do that. So that's exactly why the Ninth Circuit in Peterson versus California said it's illogical to conclude that the substitute for a grand jury indictment, which is the state preliminary hearing procedure, must contain greater protections than the grand jury provides for itself in the federal system. So if the federal system, the equivalent to the state preliminary hearing is a grand jury proceeding. The grand jury proceeding allows the federal system to determine probable cause to require a defendant to stand trial. The defendant doesn't have a right to be present in those proceedings, doesn't have a right to representation, doesn't have a right to cross-examination, or even to present exculpatory evidence. If that type of a procedure is constitutional, then Utah's preliminary hearing procedure is certainly constitutional. I could go through each of the different constitutional provisions that defendant has relied on. I'll do that very briefly, just summarize the reasons why we don't believe those apply. The Sixth Amendment, even assuming the defendant could rely on some other provision, which we don't believe he can, but the Sixth Amendment right to counsel, it doesn't create additional rights. What it does is it evaluates counsel's performance under the circumstances as they existed at the time. Now, defendant brought up the fact that there is a right to confront witnesses at suppression hearings and at sentencing hearings and at parole revocation hearings. That's a procedural right to cross-examination. It's not a Sixth Amendment right to confrontation. We know from Crawford versus Washington, the Sixth Amendment right means that the state cannot rely on hearsay evidence that a defendant has not had a prior opportunity to cross-examine. And so it's the Sixth Amendment right that prevents the state from relying on hearsay. That's completely different from saying the defendant has the right to be able to cross-examine any witnesses that the state calls. And in fact, at a preliminary hearing, the defendant will have the right to cross-examine. I think we're planning on calling 4 witnesses. Defendant will have a right to cross-examine those witnesses. But a procedural right to cross-examination doesn't mean that the Sixth Amendment right, as interpreted in Crawford, applies and precludes the reliance on hearsay.
The problem is there is not going to be any cross-examination. That's the point. That's why they want to exclude these witnesses, because they're just using statements. They're given statements from these police officers, statements from Lance Twiggs, and showing them as evidence that why Tyler is guilty in the court. But the defense will have no way to cross-examine to prove whether they're telling the truth or not.
With respect to due process and the 14th Amendment, again, you have to look at what process is due under the circumstances. And here, again, we've got a very low standard. And the state's process here gives the defendant far more protections than the federal grand jury proceeding does. Both of them determine probable cause as to whether the defendant can go to trial. And so due process doesn't supply some sort of right to confrontation that the Sixth Amendment right doesn't supply. The equal protection argument is interesting because defendant has not shown that he's similarly situated. Well, let me back up. What defendant relies on is Morrissey versus Brewer, which is the case that says defendants have a right to confront and cross-examine witnesses at a parole revocation hearing. But that's a defendant who has been convicted at trial and who is facing reimposition of a criminal sentence to serve out the remainder of his sentence. Defendant here isn't similarly situated to that type of a defendant. So he can't make an equal protection challenge based on that situation. And again, Morrissey versus Brewer does not say that the Sixth Amendment right to confrontation applies. It merely says, as a matter of due process, if the state is calling the witness, the defendant has the right to cross-examine them at the proceeding, just like defendant does at this preliminary hearing. As far as the Eighth Amendment goes, the state doesn't have any qualms with the idea that the Eighth Amendment, if we get to the point of whether or not the death penalty is an appropriate penalty here, certainly the Eighth Amendment heightened protections apply there. But we're not at that point, and defendant hasn't cited any case that would extend those Eighth Amendment protections beyond the decision to impose the death penalty, or they do cite Beck versus Alabama, which talks about instructing the jury at the guilt phase. We're not at that point. You can't use the Eighth Amendment and say, well, because this is a death case, there's super due process or super.
Nope. And they probably won't show up to any of them either.
That apply above and beyond the procedural and evidentiary rules that apply at every other stage of this proceeding. And then finally, as to separation of powers, I don't see anywhere in the federal Constitution that dictates any particular separation of powers principles to the states. And so it's completely up to the state of Utah to determine how it wants to divide the powers between its various branches of government. And the constitutional provision that's at issue here clearly says that that reliable hearsay can be defined as by statute or by rule. So the Constitution itself is giving the legislature and the courts the ability
to very telling
what constitutes reliable hearsay. As far as Your Honor's question about what you would like, what the state would like you to review as far as the exhibits go, we just renew our request that the court review all of the exhibits in preparation for the preliminary hearing.
Thank you, Mr. Ballard.
Any other questions?
No, thank you.
Okay.
Mr. Burt.
And I'm going to take this time to remind everybody that Michael Burt, once again, he is the cousin of Terrell Farnsworth, the guy that removed the SD cameras, remove the SD card from the cameras. Oh, what happened to our feed?
Court, I've circled the exhibits we're asking the court to review. They are exhibits 11, 16, 30, 31, 32, 33, and 34. I have a copy for the court with those highlighted if the court
Thank you,
would like
Mr.
it.
Burt. Yes, and if
May
you'd
I
like to
approach?
approach, you may. I appreciate it.
They should have at least
All right.
given him
Thank you
bail.
to both parties.
And Judge, could I just briefly respond
Oh,
to
of
the
course.
arguments that were made by the state? Just quickly to run through them. The state emphasizes there's a low burden at the prelim. Granted, it's a low burden, but as the State versus Virgin, VIRGIN case said, low burden does not mean no burden. And the U.S. Supreme Court in Coleman versus Alabama recognized that the burden of proof at the prelim is very low. They nevertheless held that the defendant has a Sixth Amendment right to the effective assistance of counsel. So the fact that it's a low burden does not govern whether procedural rights should be applied. And the Coleman case holds exactly that. The state says that the degree of reliability depends on the nature of the proceedings. That's true. But this is a case where the state of Utah has provided procedural rights at the preliminary hearing, unlike grand jury proceedings. There are rights granted by statute to counsel. There's constitutional right to counsel. There is a right by statute to call defense witnesses, to subpoena witnesses. So the court has to take those procedural indicia into account in determining what other rights might be applicable. And both the U.S. Supreme Court and the Utah Supreme Court has said that the preliminary hearing is a critical stage of the proceedings. The state says that, citing this Ninth Circuit brief opinion, the Peterson case, that it's logical that the preliminary hearing must have greater protection than grand jury proceedings. It might be illogical, but the reality is that defendants are accorded greater rights in preliminary hearings than in grand jury proceedings. There is no right to counsel at grand jury proceedings. There is no right to subpoena defense witnesses at a grand jury proceeding. And yet in Utah, as elsewhere, defendants do enjoy those rights to certain protections. And once having defined that it's an adversary critical proceeding, the state has an obligation to provide the tools necessary
most states
to make
do.
that confrontation meaningful. State emphasizes that the defense has a right to call witnesses. Theoretically true, but irrelevant in this case because
Doesn't make
as
it
the court
right,
will
though.
see from reviewing the exhibits, how the state proposes to make its case in this case is exclusively through the use of hearsay. So calling a record custodian or a police officer who has no knowledge about the essential elements of the offense, the defense could cross-examine that person on some chain of custody issues, but it's got nothing to do with the critical issues before the court, which are the essential elements shown by probable cause. And in this case, those elements are going to be satisfied by hearsay alone. The defense says that, or the state says that there's no equal protection problem here because we're not similarly situated to probation or parole violators. In all three of those cases, the interest at stake is whether the defendant should be confined for prolonged periods of time pending the outcome of this hearing. So a parole revocation hearing, especially the preliminary parole revocation hearing, is very, and in fact, it's indistinguishable from a preliminary hearing. The goal is the same, to determine whether there's cause to hold the person, deprive that person of liberty pending further proceedings. So there is an equal protection violation here. The state says that the court can only look to the Sixth Amendment. As I understand the argument, the court cannot look to procedural due process as guaranteed by the 14th Amendment. It cannot look to equal protection. It cannot look to the 8th Amendment. it cannot look to any other doctrines beside the Sixth Amendment to determine confrontation. And we've pointed to the court a long line of cases in both the U.S. Supreme Court and the Utah Supreme Court, which
I'll get into that
refute
afterwards.
contention. It's clear the court has an obligation to look at whatever constitutional provisions are implicated by the procedure in question. And the Utah Supreme Court, when it was looking at the subpoena powers case, looked at whether the act violated confrontation rights, equal protection, separation of powers. No one ever suggested that the court had no power to look at various constitutional theories. That theory is not supported by the case law. And then lastly, the state says that we cited no cases to the court saying that the Eighth Amendment applies to the preliminary hearing procedure in this case. And that's simply not true. Gregg versus Georgia said that every procedural protection must be observed in a capital case, not in a capital trial, in a capital case. And as charged right now, this is a capital case. And we've also cited to the court the Ford case, Ford versus Wainwright, also along the same lines, saying that in capital proceedings, there's a heightened need for reliability. And then lastly, in our reply, we cited a whole string of state court cases, which hold that at the preliminary hearing, not the trial, the preliminary hearing, the court has an obligation to employ a heightened standard of reliability. Thank you.
Thank you. All right, thank you to the parties. We're turning to the last item, and just cutting to the chase, does the state oppose defendant's request on docket 593?
Can I have just a moment?
And there is also the scheduling of the responses to an EMC request, which we discussed.
Okay, well,
We
thank
need
you
to
for
deal with that as
reminding
well.
that. Thank you, Mr. Novak.
Your Honor.
If you would like to approach the lectern, Mr. McBride.
Your Honor, so this is basically a motion to begin the process of compelling and of getting a subpoena for an out-of-state witness.
Yes.
Here's the issue is, we know that from the pleading that the out-of-state witness's attorney has declined to accept service for their client. And this witness has appeared by 1102. We believe that that's appropriate and satisfies probable cause. The rule requires defense counsel to certify that this witness is necessary and material to the probable cause determination. Under State v. Lopez, we don't believe it is. We got this at 8:03 last night. I looked at it for the first time just moments ago. What I'd really like to do is have a couple of days to respond to this. I know time is of the essence, but that's where we're at. So I really don't want to respond right now. If I did, I'd probably submit on what I've said right now.
I see. Thank you. To defense, is there any additional briefing needed in addition to what you've submitted on docket 593? And so I'm just seeing if there is, trying to create an expedited.
Only to respond expeditiously to whatever the state files. So for example, and again, we're both going off the fly. I'm now responding to Mr. McBride's
I
statement.
think
This
he
is
was
not
talking
the
about
Lopez
just
situation.
Utah.
The witness is not the victim in this case, as Your Honor knows. So it's not a Lopez situation. It's a question of whether the witness is a material witness. So I think to squarely answer the court's question, we need a very short period of time after the state responds, and if the witness's counsel wants to respond, to file, I guess, what we would call a reply. But we are moving we can move as quickly as the court requires.
Thank you. To the state, and how much time, and again, I realize that this is appeared on the horizon.
We can have till Tuesday close of business.
All right, so we're looking at Tuesday, the 16th of June.
Yeah.
All right, close of business. Mr. Novak, with that information.
I think Thursday, the 18th.
All right, I close of business as well.
And actually, in some ways, this may or may not sync. Anyway, go ahead. I'm sorry.
Well, and I know where you're going. Does that sync pretty closely with the last remaining issue, briefing on the potential? Well, the problem with that is until it's filed, the request for an EMC, that starts the time. My lawyer math doesn't get me to how close we are to the prelim off the fly, but that's the trigger point.
I was an economist before I was a lawyer, so
All right,
my
I'll
math
allow
might
you.
help. So you just want to hold that there for a second and move on to the other one and then see if they're in sync, or what did you want to do?
Well, and I'm fine. It sounds like we have a good understanding for the briefing on that particular docket 593. So that's been resolved. Turning to the last issue is in regards to the EMC. When would the 14 days?
So right now, the court's order from May says that media requests need to be filed 14 days before the proceeding. 14 days before the proceeding, which is on July 6th, is June 22nd.
So
Which
a
would
week
not-
from Monday.
Pardon?
A week from this coming Monday.
So this is what I was going to propose, and we did meet and confer about this. And my understanding of the state's position is they don't want the court to change its order. Okay, so I understand that's their position, but here's our proposal. We propose that for purposes of the preliminary hearing of July 6th, if it proceeds on that date, that the court adopt the following schedule. Any request for electronic media coverage should be filed next Wednesday, June 17th. And we will take it upon ourselves, meaning Mr. Robinson's defense counsel, to personally notify counsel who've entered their appearances on behalf of the media entities of any new deadline that the court sets today. So we will notify them so that the court doesn't have to rush into publishing an amended order unless the court wants to do so. But we can notify them, copy the state, copy the court staff. It's a form, as I understand it. This is the event. This is who's going to be behind the cameras. It's submitted. Okay, it's not a complicated document. So this is my suggestion, is that we will notify the media representatives today that any request for EMC needs to be filed with the court by the 17th, which is Wednesday. Today's Friday. We have an issue which is a small delay between when it's filed and when it's docketed. And so what I'm going to suggest is that 2 court days after it's docketed, we will file, anybody who's opposing it will file a response. And then 2 more court days for anybody who wants to respond to that, and 2 more court days for a reply. The court's already set page limits, which are very modest. I think it's 4 pages, and 3 pages. That's fine. The court has said there won't be any oral argument. That's fine. But if my schedule plays out correctly, and we got a docketed EMC request on the 17th, and we filed our response on the 19th, and the state filed any response to our papers on Monday, the 22nd, and then we filed a reply on the 24th, it would be fully briefed by the 24th, which gives us 6 + 6, 12 days before the prelim.
All right. Thank you, Mr. Novak. Does the state wish to be heard on this issue?
Yes, Your Honor, thank you. I think we're not discounting the importance of and the significance of the media issues in this case. But I think it's significant, as Your Honors already noted earlier this morning, that you granted a very generous opportunity to deal with these electronic media requests. That it's
Yeah, I
far more
noticed
generous
he's starting
than
to
what
go
the rule
bald in the back
requires.
there too.
It appears to me that
No
what the
wonder all the
defense wants
stress will do
is an
that.
opportunity to get a ruling from this court on electronic media requests, so that then if it's a ruling that they don't agree with, that then they can seek yet another interlocutory appeal and perhaps file a motion to stay this case. And if you look at the procedure that the rule has already established, the controlling rule 4-401, the rule does not contemplate appellate review of every electronic media coverage order. And that's clear from the fact that the rule only allows 1 day notice for a request for electronic media coverage. And in fact, it says that the court on good cause can grant a request for electronic media coverage. It can shorten the 1 day time. I think it could be, as the hearing commences, if there was good cause. So as the court has already established its schedule, it allows 14 days before the hearing for the request. Under that current schedule, the court could have a ruling on the request by July 2nd, which would be before the hearing. So we don't believe that this procedure, which presumes that electronic media coverage, those requests will be granted, that it needs to be set up so that there can be the potential for appellate review of every one of those orders.
Thank you. All right. Thank you to the parties. I appreciate you conferring with each other and trying to find a solution. I'm going to respectfully decline to adopt what Mr. Novak presented. And here's why. There's nothing that precludes the media from filing today. That request and being ahead of the deadline. And again, that's outside of my purview. It's their choice if they choose to file or if they choose to file one at all. And so the court will rely upon the previously set schedule. Again, if the media files early, that doesn't preclude the parties from filing as soon as they can or they wish to, and the court still having sufficient time to do its duties. And so that's the ruling of the court as it relates to a different schedule as it relates to media requests for coverage, EMC, of the preliminary hearing on July 6th. It goes to the very last issue, which is the court is taking these two issues argued today under advisement. And as this court typically does, I always like to review everything. And I appreciate the quality of the arguments, the quality of the briefing, and what is clear to me, the hard work of both defense and prosecution and the seriousness applied to these important issues. If you wouldn't mind taking a look at your calendars, the court has an opening on June 22nd at 9:30 a.m. to issue rulings on both of these matters. And as is traditionally has happened, it's done on WebEx, but of course I'll hear from the parties on their preference as well as the attendance of Mr. Robinson at that.
You too.
hearing.
Thanks, Daisy.
That date works for the court, and we would prefer WebEx for the state. Sorry.
It's okay. 9:30 in the morning.
That's fine with Mr. Robinson's counsel, and we will ask that Mr. Robinson appear by WebEx audio only from the jail.
All right. Thank you to the parties. Anything
Very
further?
true.
Any party needs the benefit of the record before we go into adjournment? All right. Thank you all. And court is now adjourned.
All right.
That's very true, Adora, except that, like I said, Lance is not going to actually be there. Lance is going to be, what they're doing is they're going to just have a statement read by him. And that's part of why they're arguing the hearsay. They want to preclude the hearsay arguments because the state, the only case that the state has so far really is just hearsay from police officers on the scene, from Lance and other people, saying Tyler's guilty for this and this reason or whatever. But they're just statements. They're not going to be there in trial to be cross-examined. It's just they wrote down their statement. So that the defense has no way to cross-examine them, to prove whether what they're saying is true or not. And that's basically what it comes down to there. Yeah, absolutely. Thank you guys all for joining me. Yeah, this hearing was about a couple things. It was the first part of the hearing was about the motion for contempt against the prosecution. This was an evidentiary hearing for that, because they went on Fox News and other media outlets. When it came to the bullet not matching the gun or whatever, they went on all those different medias, stations, basically prejudicing Tyler Robinson, saying he's guilty or whatever. And the defense wants to find them in contempt for that and sanction them. And the sanctions that they requested are for them to remove the death penalty. So the state could no longer seek the death penalty. So that was the first part. And by the way, the judge has not made any rulings today whatsoever. He's taken them all under advisement, and he will rule on them at a later date. So we don't know the outcome of any of this. And then the second one was about the hearsay, like I was just explaining, where the state, for the preliminary hearing, the only evidence that they really have are these hearsay testimony, which is statements, written statements by various witnesses, like police officers, like Lance Twiggs, etc. And they want to introduce them as evidence of probable cause to find Tyler guilty. And the defense is challenging that, saying that, they put a motion saying it should be excluded because the defense does not have any way to cross-examine. If the witnesses aren't going to be there, you can't face your accuser. So you have no way to cross-examine them to see whether what they're saying is true or not, or whether these are even credible witnesses. So that's what that argument was. And that's basically what this is about. Yeah, he should have to appear. He absolutely should have to appear, especially considering that we've already proven that the text messages, and that goes to, they really don't have any evidence outside of hearsay that Tyler Robinson is guilty. Because the text messages that they supposedly say that he authored, we've proven that they were written after he was already in custody in, I think Washington County. Yeah, Washington County. So he was already in custody in the jail, or not the jail, but the sheriff's office in Washington County, and they already taken his devices at that time. So there's no way that he could have authored those Discord messages if he was already in custody and didn't have his devices at the time that those messages were sent, this alleged confession or whatever. So they don't have that. And then the only other evidence that they really have against him is that they have DNA and fingerprints allegedly on the rifle. Well, the problem is that rifle was not on the scene. That they can't prove that rifle was actually at the scene. The rifle was found wrapped in a towel in a wooded area, allegedly, in another area, in somebody's house by a chicken coop or whatever. So it wasn't even at the scene. They can't tie that rifle to the scene. They have no way to do that, especially since the bullet does not match the gun. So they have no way to actually stop Cat. So they have no way to actually prove that Tyler was really there. And the only other thing besides that they have are where they say that his car was there driving around Orem, Utah at, hold on, let me look this up real quick. Give me a second. Okay, yeah, so they say vehicle on arrival. They say they have camera footage of a gray Dodge Charger arriving on campus at 8:29 a.m. But the only problem with that is that it contradicts the stuff that we've seen of him walking through the neighborhoods. The times don't line up. So they really don't have anything, any evidence to say Tyler was actually there, participated, and they definitely don't have anything to say that he was the trigger man or whatever. Because, well, one, we know that what gun was not even fired, but secondly, they have nothing linking him to even being on that roof or being on that campus besides this hearsay evidence of whatever the police officers or witnesses that that they're saying that they can't argue. Yeah, nothing. That's what I'm saying. Nothing. You know, they have DNA, but and by the way, and that's the other thing with the DNA is, okay, they got Tyler's DNA on the rifle, which, like I said, was not even at the scene. They cannot place that gun at the scene of the crime. They cannot prove that that was the murder weapon. But besides that, not only is Tyler's DNA on that gun, there are five other people's DNA that were found on that gun. So who are the other five people whose DNA were on that gun besides Tyler? And secondly, of course, his DNA would be on that gun because it's his gun. You know, why wouldn't his DNA be on his gun? If someone planted that gun in the woods to try to make it look like he was guilty or was the one that did it, you know. Yeah, and that's another thing, strange thing is, you know, they had canine dogs, you know, the gun sniffing canines and stuff that went out there looking for the gun. They could not find the gun. And then the FBI showed up and just, oh, what do you know, out of nowhere, the cops looked for the gun, the canines looked for the gun. They didn't find any weapon, nothing. They could find nothing. They even checked the same area where they found the gun the first time and found nothing at all. But yet the FBI shows up and then just magically, oh, go check over there. Okay, here's a gun. Here's a gun, guys. We got the gun. Yeah, to me, that gun was definitely planted. Yeah, absolutely. Yeah, no, they can't have anything secret. They have to, you know, they have to put in their probable cause statement all the evidence that they have. And we've already seen their probable cause statement, and it's all garbage. It's all bullshit. You know, and that's another thing. They claim surveillance video of him jumping off the roof or whatever. You can't prove that's him. The video that they showed, the person that they see jumping off the roof is about the size of a little ant. You know, you can't make out that person and prove that that's Tyler Robinson jumping off that roof. That could be anybody. And as far as the stairwell photos, that's not Tyler Robinson in those stairwell photos. I don't care what anybody says. That's not Tyler Robinson. You know, we've done facial recognition comparisons. You can also see that the earlobes don't match. They're, you know, I forget whether his are attached or unattached, but whatever Tyler's has, his earlobes either are attached or not attached. But the person in the stairwell is opposite of what Tyler has. So if Tyler has attached earlobes, then the person in the stairwell has unattached earlobes. So it's not the same person. Yeah, they you know, they do not, you know, if they can get the hearsay evidence thrown out, then they stand a good chance of getting these charges dropped on him, in my opinion. Okay, so let me go ahead and read super chats real quick from people. And if you want to send a super chat real quick, I'll just drop it in the chat one more time for you guys. I'm not I am not monetized here on YouTube. So if you want to send a super chat, you can do it this way through Spot Fund. You can leave a donation and then a comment. You can leave a comment, and I will read your comment on air like a super chat. So let's go ahead and pull them up. All right, guys. So actually, before I do that, in case you guys haven't noticed, let me go ahead and show you guys. Turning Point sent me a third cease and desist letter for anybody who has not been paying attention or hasn't seen my X feed. But Turning Point has sent me a third cease and desist letter already. Let me make sure I'm sharing this. Give me a second. Okay, yeah, very good. So they sent me a third cease and desist letter here. Says, "Dear Mr. Campbell, we are intellectual property counsel to Turning Point Action." Actually, let me pull this up somewhere else. That way I can actually read it, because this is a little too small for me to read. Actually, I can zoom in. Never mind. We'll do it this way. There we go. All right. "Dear Mr. Campbell, we are intellectual property," and this was sent from Faegre and Drinker. "We are intellectual property counsel at Turning Point Action, TPA. We write regarding your unauthorized use of a photograph of Charlie Kirk, owned by Turning Point Action, the photograph, on X through the Project Constitution across the account. TPA is a nationally recognized nonprofit organization dedicated to promoting social welfare through raising awareness about free markets and capitalism." Could have fooled me. "Initiating civic action among the younger generation," seems like you're targeting boomers, "and educating youth," you mean indoctrinating youth, "in order to be a resource for free market thinkers to further advance their values to educate and empower the younger generation. Charlie Kirk was the founder and CEO of Turning Point Action before his assassination on September 10, 2025. Turning Point Action maintains professional photographs of Mr. Kirk for use in connection with the furtherance of his mission through its organizational activities, events, publications, and promotional materials. Turning Point Action is the owner of all rights, title, and interest in and to the photograph, including the exclusive copyright therein. As the copyright holder, Turning Point Action possesses the exclusive rights to reproduce, distribute, publicly display, and prepare derivative works of the photograph under 17 U.S.C. 106. It has come to Turning Point's attention that the account prominently displays the photograph of Mr. Kirk without Turning Point Action's authorization or license. Specifically, the account at my account, obviously, features the photograph in a prominent position visible to the public, thereby reproducing and publicly displaying Turning Point Action's work to the account's followers and the general public without permission. And then they show a little picture, obviously, of my logo that they take action with. You know, they have a problem with me having Charlie on my logo. Turning Point Action has not granted you or any person or entity associated with the account any license, authorization, or consent to use, reproduce, display, or distribute, or otherwise exploit the photograph. Use of the photograph is wholly unauthorized. and constitutes copyright infringement. Moreover, the prominent display of Mr. Kirk's photograph on the account creates a false impression that Turning Point Action, Mr. Kirk, or his estate endorses the account or the content posted thereon. Unauthorized use of Mr. Kirk's likeness to imply such as an unauthorized use of Mr. Kirk's license of Mr. Kirk's likeness to imply such as an endorsement constitutes an additional harm to Turning Point Action and may give rise to claims under state and federal law, including unfair competition and false endorsement. Turning Point Action, and this is bullshit. We'll get into that. We'll get into all that in a minute. Turning Point Action further demands that you refrain from any use of Mr. Kirk's name, image, or likeness in any manner whatsoever, whether in connection with the account or otherwise. Any unauthorized use of Mr. Kirk's name, image, likeness risk creating a false impression of Turning Point Action or its affiliates' endorsement, sponsorship, or association with your activities, and may subject you to liability under applicable right of publicity, trademark, and unfair competition laws. The unauthorized use of the photograph constitutes infringement of Turning Point Action's exclusive rights under the Copyright Act of 1976, 17 U.S.C. 101. Specifically, by reproducing and publicly displaying the photograph without authorization, you have violated Turning Point Action's exclusive right to reproduce the work in copies under 17 U.S.C. 106. Its exclusive right to distribute copies of the work to the public under 17 U.S.C. 106.3, and its exclusive right to display the work publicly, blah, 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 whatever. Your use of the photograph does not constitute fair use under 17 U.S.C. 107. The photograph is a creative, professional work and used prominently and in its entirety for purposes that do not transform the original work or add new meaning, expression, or message, and the account display of the photograph serves as a substitute for TPUSA's own authorized uses and undermines the potential market for the work. Accordingly, Turning Point Action demands that you immediately take the following actions. Now, this is the fun part. Number 1, permanently remove the photograph from the account, including from the account's profile picture, header image, banner, post, replies, and any other location where the photograph appears. Cease and desist all use, reproduction, distribution, display, and exploitation of the photograph and any derivative works thereof on any platform or medium. And this is the really crazy one right here. Cease and desist all use of Charlie Kirk's name, image, likeness, voice, and persona, whether in connection with the account or otherwise. So they basically want to tell me that I can't talk about Charlie Kirk, I can't mention his name, I can't use videos of him, I can't use his voice, I can't even have nothing to do with Charlie Kirk. I can't even report on Turning Point or Charlie Kirk at all. Confirm in writing that the photograph has been removed and that you will not use, reproduce, or display the photograph or any substantial similarly image in the future. Identify all other platforms, accounts, websites, or medias of which you have used, displayed, or distributed the photograph, and preserve all documents and communications concerning your acquisition, use, and display of the photograph, including the source from which the photograph was obtained. Turning Point Action is prepared to pursue all available legal remedies if you fail to comply with the foregoing demands, including without limitation filing a DMCA takedown notice with X, in other words, trying to get my account banned, seeking injunctive relief in federal court to prevent further infringement, trying to get a protection order against me to bar me from using it, and false endorsement, and pursuing actual damages and attorney's fees, filing a lawsuit. Please provide written communications of compliance by close of business today. Obviously, that's today's date. Nothing in this letter should be construed as a complete statement of the facts or law and as a waiver of any rights, claims, remedies, or arguments of which are expressly reserved. Best, Louis T. Perry. So yeah, that's what these morons sent me. This is the third cease and desist that they've sent me so far, or should I say, love letter. Obviously I'm going to tell them they can go shove it up their ass. When it comes to Charlie's image, the picture, I would say, as far as, I'll put it this way, as far as everything else that they're saying here, do not use any Charlie's likeness, image, anything or whatever. That's completely ridiculous. That's unconstitutional. That violates free speech rights. That violates journal. They can't do that. And as far as the actual photograph that they're talking about, I would challenge them to prove to me that they own the copyright for that photograph. If they show me they own the copyright to that photograph, then we'll talk. Then I might be willing to, change the photograph or remove the photograph. But as that stands right now, I've not been able to find anything that says that they own the copyright to that photograph. So unless they show me that, then we're kind of at an impasse here. Yeah, drop the receipts. Absolutely. That's it right there. Drop the receipts. Show me you owe show me that you own the copyright to that. I know for sure you don't own the copyright or trademark to Charlie Kirk's name, his likeness, any of that. One, because the attempt to even copyright his name right now is still pending, and it was challenged by Charlie's parents. So you don't even own that. But even if you did own that, that wouldn't prevent me from talking about him because he's a public figure, and that wouldn't prevent me from reporting on him as a journalist. So, yeah. Anyway, so that's what's going on. I haven't responded to them yet. But that's basically what my response is going to be. Basically, prove it. And as far as them, and that's the other thing, is them saying, let me go back to this section here, where they're saying, hold on. The unauthorized use of Mr. Kirk's likeness to imply, or what hold on. Okay, here it is. Here it is. Moreover, the prominent display of Mr. Kirk's photograph on the account creates a false impression that Turning Point Action, Mr. Kirk, or his estate endorses the account or the content posted therein. Bullshit. I call complete bullshit. It's very obvious to anybody out there that I am not endorsed or affiliated with Turning Point whatsoever. I am adamantly against them. In fact, all my content is railing on Turning Point. Literally, all my content is attacking Turning Point. So I don't think anybody in their right mind would accidentally think that I am acting on behalf of Turning Point. That's completely ridiculous. Makes absolutely no sense whatsoever. Yeah, so that's what we got there, guys. Erica hates his parents. Copywriting his name is diabolical. Yeah, I agree. And on top of that, it once again it shows that she is not grieving whatsoever, because I believe she filed copyright for Charlie Kirk, the name Charlie Kirk. I believe she filed that or that trademark, not copyright, the trademark. I believe she filed the trademark for that within like 4 or 5 days after Charlie's death, within a very short time. So instead of being concerned about grieving, Erica was more concerned about, how can I grift off of him? How can I make sure that I got his name and likeness and can make sure that we can grift off of him? That was her concern. Why am I asking for super chats? Well, because I'm not monetized, okay? So if if people want to support me, I should be able to get paid for my work just like anybody else does. You don't see Barron, Coach Colin, Candace, you don't see any of them, doing it for free. Why should I? This is my full-time job. This is how I make a living. So why shouldn't I get paid for it? If people want to support me and people want to donate, then why can't they? I'm giving them an option too. I'm not begging for it, but I'm letting them know if they want to, then that's where they can go. We are all Charlie Kirk. I hope you no longer hold sway. I got it. I hope you said fuck off. Yeah, absolutely. We are all Charlie Kirk. They can kiss my ass. I will not bow to them. Anyway, guys, so by the way, let me go ahead and read those super chats while we are at it. So, where did I leave off last time? Okay, I think I left off with him. Okay, so Delaney Shell donated $50. Keep up the great work, brother. Thank you very much. I appreciate your donation. Cindy Lou Exholt donated $25. Thank you, Colin, for your hard work. At Silly and Zaza. Well, thank you very much. I appreciate your support. We can't do it without support from people like you, especially because they've been really attacking my account hard with bots to try to get me taken out of the algorithm and to limit me tanking my views, so they tank my income, and they've been successful at that. That's why I've had to put a disclaimer on the bottom of all my posts saying, if you want to support me, here's a link, because the only way I can even pay the rent anymore is because of the help of you guys. So, Birdie Seraphin donated $25. Thanks so much for your bravery. May our Lord Jesus and his most holy mother keep you safe. Saint Michael protects Colin, Project Constitution. Amen. Thank you for that. And I agree. I absolutely 100%. I have God on my side. I know I'm doing the right thing. I know God is the only one I have to answer to. There is nobody that's going to make me change course besides God. If God, whatever God tells me to do is what I will do. And God is put me on this mission, and this is my life's mission, and I'm going to see it through. Judy Montgomery donated $20. Keep up the great work. God be with you in this spiritual war. The good news is Christ already won. We just have a little longer before he shows himself. And then every knee will bow before Jesus Christ, King of Kings and Lord of Lords. Thank you, God, for soldiers like Project Constitution. Amen. And I agree. This is a spiritual war for sure. It's good versus evil. And we have won. Honestly, the light always wins. And it's only a matter of time before Jesus comes back. And I completely agree with that. Christine Jones donated $50. Rotten position to be in for telling the truth. I know, right? You think, especially because Charlie was all about truth, all about asking questions. You think that they wouldn't try to attack somebody for asking questions and trying to get to the truth, especially when it concerns who killed their founder and CEO and supposedly best friend. Lourdes Moreno donated $25. We have your back. You're not alone. Christ is King. Thank you very much. I appreciate the help. Thank you for the donation. And yeah, I'm gonna go max. I've gone max this whole time, and I'm not gonna stop. Anonymous donated $20. Nice work, Patriot. Don't ever quit. Thank you for that. And I won't. Like I said, this is my mission. This is what God told me to do, and I am going to see it through regardless. They're not going to stop me. If they get my account banned, then I'll just make 10 more new ones. I don't care. Thank you all. John Strazic. John. I'll just say John. I don't want to butcher your last name. John donated $5. Thank you for all you're doing, Colin. We are all out. We are all out and love the work you are doing. God bless you. Well, thank you very much. I try. Obviously I don't get everything right. Nobody does. But I only care about the truth. I've proven that time and time again. And if I do get something wrong, I'm humble enough to correct it, make sure I correct the record and move on. Because that's all I care about is the truth. I don't care about, chasing clicks or views or, faking stuff. That's not what I do. That's, it's not my purpose. I want to solve Charlie's murder. That's my purpose. I want to get transparency. I want to expose the people that betrayed him. And, we need the truth to do that. And that's all I care about is the truth. I'm on a fact-finding mission. And you got to ask questions to find the truth, to get the facts. Anyway, so let me just update it, make sure nobody else donated anything. Nope, right? I don't think so, right? Yep, nope. Okay. Anyway, guys, so that is our show for today. Thank you all for joining us. And like I said, as far as a court hearing, the judge did not make any rulings today. He's going to make a rulings at a later date. He's going to take them into consideration and make the rulings at a later date, like he normally does. So this really isn't any surprise. So that's it. So thank you guys very much. I love you all. I appreciate you all. And until the next time, see you guys later.